Good evening, everyone. BriefCASED is a digital platform providing case briefs with judgments, legal news, and legal study material. It specializes in reliable case briefs which are kept precise with the essence of the judgment to provide our users with the best information with efficiency. And accordingly, learning made efficient is our motto. After organizing successful webinars and panel discussions in the past, we at BriefCASED are back with our series of webinars, which includes a wide range of topics to impart legal knowledge on the fundamentals of law. Our topic for the first session is emergence on the concept of temporary non-use during lockdown. Now, the question as to whether the lockdown would entitle tenants to claim waiver or exemption from the payment of rent or suspension of rent is what is to be answered in this very informative session. As for the first speaker for our webinar, we have with us our learned Mr. Sanjay K Chadha, who is the founder, member, and partner at BSK Legal, luminary with more than 25 years of experience in the field of law. He is also a huge contributor in the news and print media. It's a pleasure to have you with us, sir.
Thank you.
Sir, so prompting the first very question to you for the same, for today's session. So, sir, it would be of utmost importance if you can enlighten the audience as to what problems are actually faced by the tenants in the COVID pandemic and what is the situation prevailing at this point of time. So, if you can enlighten us upon that first.
Look, the first thing first, that it is an extraordinary situation. We all are aware of it. These are exceptional situations, and I can say it with very confidence that none of us is left from suffering, be it small or be it bigger. Suffering means from one point or the other, it has restricted, it has disturbed our normal routines. So it is an exceptional circumstances. As I said, none of us means all Indians, everybody, entire world is affected by one or the other count. The other day, there was an article in some of the newspaper that how big is the loss to the lawyer community. And the number, if I may tell you, 20,000 crore rupees are lost by the lawyer community in 2 months of the lockdown. That's what I was just giving you an impression. So the effect of this primarily upon, as I said, each one of us have been affected. So of course, the landlord and the tenants are also affected. So it is very, very clear if a tenant's shop is closed for 2 months, nothing he will be earning. Similarly, the same goes with each and everybody. So be it, we will talk about the labor crisis, we call about migrant workforce, or whatever terminology, the organized sector, the unorganized sector. In one word, I can say that it is nothing, but everybody is affected from it. And all of you, I must say, will totally agree with me on this particular count. Now, as the topic suggested to me is basically I have to confine to relationship between the landlord and tenants only, the leasee and the leaser, as we call in more technical term. So this is what is the scenario. If may I say, the gravity is quite high. Nobody was expecting that the government will ask them to remain shut for such a long period. And as we call in Hindi, "Jaan hai to jahan hai." So we were following the same thing. First is life, then we will think about anything else. So this is what Bhumika, I would say the magnitude of the problem is this. And then now you can, if you want to, because I have answered your question now, if you want me to proceed further with the topic, I can do so, or you want to say something, please. Because
So
if it is in question answer form, then I will take it question answer form.
Sir, it's totally up to you. If you want me to ask or proceed with the next question, I can totally do that. And
So let me take your next question, and then I'll because I will continue, and if something is left out, then you come up.
Sure.
Will that be fine?
Yes, sir. Totally.
Great.
So moving on to the next question. So before this pandemic had actually hit us, so what was the legal position of the tenants according to the Indian laws? Or what laws actually define the liabilities of a tenants, and how are they actually guided through law?
So very nice that meaning what are the legal provisions which govern the landlord and tenant relationship?
Yes.
Primarily, if you may ask me, this particular set of law is largely governed by the provisions of Indian Contract Act 1872. We all know, most of us are law students here, as in the beginning my co-host Bhumika has said. So Indian Contract Act 1872, we all are well aware what is offer, what is offer or proposal, what is acceptance, what is, and as far as the tenant landlord relationship is concerned, in agreement, whether it is a verbal agreement, I am emphasizing here, whether it is a verbal agreement or an agreement which is in writing, this contains the terms of the agreement. The agreement is the one which lays down all the gist of the relationship as to how the relationship has to go on. Terms of the contract are part of that, as to for how many months, how many years this contract has to go, what is the consideration, what will happen in case of the breach. All these things are covered in the agreement. So primarily, as I said, largely the law of contract, that is the thumb and the fundamental law of contract, that's Indian Contract Act 1872, governs the relationship between the leasee and the leaser, landlord and the tenant. First, the second thing which is very important here is the law which we see. If I elaborate it, specifically, I will come to that later on. The other law which is very important here is the law of Transfer of Property Act. And more so specific, if you may ask me, section 108 of the Transfer of Property Act provides for both the provisions. One provision is that basically which talks about how a tenant has to use the premises. It is contained in this section. And how the tenant has to give the rent for the premises. So section 108 of the Indian, Transfer of Property Act mentions that. Now, other than that, one thing just struck to my mind while talking about it. Let's say, there was a time, there was an era when we used to have, I would say, I can put the number also there. Now, at the time of independence, our law was such that we were favoring the tenants. It was a law tilted towards the tenants. There was a So at that point of time, now the law has changed. So for an example, as far as the Delhi is concerned, we have our own Delhi land, Delhi, which act is that? Delhi Rent Control Act. I'm sorry, it took a minute. So as I always, I have a habit of speaking extempore. So sometime I may wrong. So I request you to correct me. So Rent Control Act, Delhi Rent Control Act was there, which, as I said, initially was tilted towards, even the Rent Control Act is still tilted towards the tenant, and it favors the tenant. And without the specific reasons which are mentioned in Delhi Rent Control Act, you cannot ask a tenant to leave the premises. One, I'm coming to the point, but this law need to be explained. One very important figure is, I would like to share with you. This covers, Delhi Rent Control Act covers, we are talking about Delhi only. If we go out of other states have their own specific rent control acts. Now coming back to Delhi Rent Control Act, may I give you the figure? Figure is 3,500 rupees. Any premises which is rented for rupees 3,500 or less would be covered under Delhi Rent Control Act. This was just an information coming back. And now the tilt which was there in favor of the tenant by virtue of various judgment of Supreme Court and High Court, Delhi High Court, that tilt is, I would say, is little bit reduced. But as it is a statute, nobody can be above a statute. So if any premises where the rent is above 3,500 rupees, which will be covered under the Rent Control Act. That's just an information I was giving to you. Now, what that agreement, as we discussed, agreement contains what? Agreement always contains the terms what I just mentioned, and it covers all foreseen and present, foreseeable and present situation, I would say, if may I say so. Anything which you could have foreseen, you will be writing that only. You will not be writing something which you don't foresee. Today, you cannot foresee something, you cannot incorporate in the terms of the contract. So this is a very thin line which you have to remember. Yes, somebody is asking. Shreja is writing something. I can't read that.
We'll take the questions at the end, sir, for the audience. Their questions we'll take at the end.
Okay, that's precisely. I'll abide by that also, and I would request all of you to keep your questions ready, and we will answer everything. So, as I said, while making a contract, a person only incorporate those things which one can reasonably foresee. I think all of you will agree to it. Now I come back to one very important clause which all of you know, and which we have seen that as a standard form of contract, as a standard terminology in a contract, we use it in almost all the contracts. That's called force majeure. What will happen in force majeure clause? What will happen in case something happens which is rather an act of God, which is unforeseen, which is not. So any circumstances, the right word would be any circumstances which is beyond control of a human being, beyond your control. Extraordinary circumstances, extraordinary event, if I may say. As I said, force majeure clause is a standard clause, and we find it that most of the agreements have this clause. standard clause. As in practice, you find that almost all the agreements contain this force majeure clause. And this clause is very, very commonly seen in almost all the agreements. Now, the question which is relevant today, Bhumika has asked me, what are the provisions? So I'm summarizing once again. I said primarily Indian Contract Act, which will be covering the relationship between the lease landlord and tenant. One. Second is TPA, Transfer of Property Act, which will be taken care here. And we have to see the most important and relevant section is Section 108 of Transfer of Property Act. And I have also mentioned the specific state tenancy act, like for Delhi Rent Control Act. So these are the primary three laws, Bhumika, which will be taken into account while anything relating to the lease premises, or if I may say so, the landlord and tenant relationship. Now, as I had started and initiated and explained to all of you what is force majeure. Force majeure clause, as we were discussing, and I have said that this is now the question which I put to myself and which was relevant as far as this current pandemic situation is concerned. The question was that whether the corona period will be taken as force majeure or not. This is what the relevant or the key question. And if at all, yes, then what are the consequences? What will be the effect of this force majeure upon the tenant, upon the landlord? So I would say when we see that an event is force majeure or not, then you have to have two ingredients, two important points you must see. And those 2 points, one, whether the event is beyond reasonable control. As I said, human being without, not in control of a human being is what, whether that is there. So that is one requirement. Meaning thereby, whether the act which has happened is beyond my control, beyond the control of the human being. And the second part, which is very important, is it must affect the ability of the parties to perform their duty as agreed in the contract. So these are the prerequisites for force majeure. Now let us see the current situation. Let us put this current situation into this test. As I said, these are the two conditions. Whether these two conditions are fulfilled here in this case or not, then first condition, as I said, event beyond human capacity. So the answer to it is pandemic. I may put to you whether pandemic was in control of human being. The answer would be no. So yes. Similarly, lockdown by the government, whether this was within the control of any of the persons, the answer would be no. So we fulfill the first criteria. Now let us come and see whether the second criteria is fulfilled or not. What was the second criteria? Second criteria was it must affect the ability of the person, ability of the party to perform. Now here is what this criteria is not fulfilled. Why? Because by one way or the other, the ability is not curtailed by this event. So as a matter of fact, both the criteria should be met for using the force measure. Now come back to very important and relevant point. I would like to mention here two incidences which you must see before. First was that Swiss flu, which was there in 1918. What was the scenario? What and in what way the situation was handled at that point of time? The answer is, at that point of time as well, the force majeure clause was rejected. And one more example I can give, if you wish to listen, that is a small example, is the example which are our own domestic examples. I'm going to give you the examples which are three examples I can give you. One was when there was a plague in Surat. Second was when there was a swine flu in Pune. Third, if I may recollect, yes, Chandigarh, there was some malaria or something very fatal thing has happened in past. And all the time we have seen that though the tenants were not able to make the payment, but force majeure clause was not accepted, not applied at that point of time. So as far as the legal proposition is concerned, I would also like to discuss here, just came into my mind, section 56 of Indian Contract Act. What are the circumstances? Of course, I will also touch base this particular section 108 of TPA, wherein it is, so let me take it one by one. Section 56, which says that when will be the contract frustrated. This is what is defined. I don't have the bare act. I can't tell you the exact wording, but the crux is this: when the contract is frustrated. The contract is frustrated when its performance become impossible. So here, performance is not impossible. Please appreciate, performance would have become impossible if let's say a shop is being tenanted by A to B, and if it is locked down, it is closed, that doesn't mean that we cannot open it. It is not impossible. It would have become impossible in case the entire shop is burned. It is as I would say, it is destroyed in fire. Then it is a frustration. So section 56, which defines doctrine of frustration, goes. Similarly, if we may discuss about section 108B, section 108BE of Transfer of Property Act, it also says that the relationship between the two, tenants and landlord, will be frustrated. The event of what I wanted to say is the event of this tenancy will come to an end if the property itself is destroyed. Something of that kind is written, is mentioned in this section also. Now, I would also like to take you proposition, what exactly has happened during this pandemic, and how we have the present scenario, how all of us have seen that what are the steps taken by the government, what exactly in the pandemic we have seen that what exactly the government has done. The most important thing is that we are also, as Bhumika's first question's answer is here also, another law which I would like to mention it here is that Epidemic Diseases Act 1897, if I'm not wrong, is also relevant, and how under Epidemic Diseases Act 1897 government has taken. It was a one-page act. Very few, 4 or 5 sections were there. The government has made changes in it. The most fundamental change which was made by the government was that now earlier the union government could have only amended the act and take decision, the steps to in cases of a pandemic like this. Only union government could have made any laws, advisories, etc. But with the recent amendment which was done during the pandemic only, the state governments are also authorized, state governments are also empowered to take such decisions. That is one. Then Bhumika, there are 2 more laws which are relevant as far as the current situation is concerned. CRPC, which provides that in cases where basically we don't follow, anybody doesn't follow the advisory directives of the government, what will be the outcome. Similarly, the National Disasters Management Act 2005 is also directed here. Cutting short, I've given you an idea what all are the legal provisions. I have also talked about the force majeure clause and how force majeure clause is not applicable in the pandemic situation. We have seen the history as to how in Swiss flu, swine flu, and Surat, Chandigarh, Pune, all those situations, though during that time also Epidemic Diseases Act 1897, we had issued various directives under it. And finally, various other thing which was very commonly seen during this pandemic was that government had issued various advisories, notifications. 1 or 2 I would like to mention here, and I will also touch base as to how they are important for today's discussion as well as. And another, I would like to welcome Mr. K. Rao. He is there. Thank you, sir, for coming. I'll continue discussion. So, the government of India union government issued various advisories. First and foremost, if I may talk about the advisory was the wage payment of the workers. There was an initial advisory came which says that nobody, no factory, no organization can stop paying the wages. But very unfortunate, later on, out of the 2 advisories, except the advisory issued by the Labor Ministry, which remained, and the other advisory was called back. Similarly, on that point, I would like to also mention here, though I have mentioned so in many of my interviews, I have already said, we have appreciated that Karnataka judgment, where the Karnataka High Court, despite an order passed by Supreme Court, where initially Supreme Court, there was an PIL filed before the Supreme Court, which Supreme Court has said that we will not intervene. As all of you are law students, I would like to mention Article 32, a PIL was filed, and wherein the central government, while represented by the Solicitor General of India, he said that we are taking good care of everything, and it will be very difficult to for the Supreme Court to monitor the progress on day-to-day basis. And Supreme Court then thereafter said that yes, we go by what the government. There is no question of having suspicious about the government. This was the judgment, meaning thereby now none of the high courts could have ever taken any steps for or passed any order in case such petition comes, because there is a law that if something is declared by the Supreme Court that we should not intervene, every High Court has to follow. Then I would say part of, as I say, that it is part of judicial activism. The Karnataka High Court came up with a judgment, not judgment, an order wherein they said that the situation is not really in control, and it is they have asked the state government what they are doing qua the workers. This was one incident. Now I come to another judgment of Honorable Supreme Court. I don't know whether we have time. Yeah, we have time. So Supreme Court in another judgment very recently, where Supreme Court has passed a final order. And what Supreme Court has said on the backdrop where the advisory by the central government, notification of the central government was withdrawn. Initially, there was a notification through which the central government had said that we pay the wage. Then that was withdrawn. Supreme Court has also said that as first, the employers cannot run the factories, etc., without the help of the employees, the workers, and even the workers cannot run their household and their day-to-day everything without the help of the employers. So, as per the Supreme Court, both of you should come into some compromise, take help of the labor commissioners of your own districts, and close the issues amicably. There should not be. So that kind of order was passed by the Supreme Court, and I have discussed that on various media platforms on these three judgments. Now, why I have touched these judgments today? Why in the because I wanted to tell all of you, each one of you, that various advisories, various notifications have been passed by the government. We cannot say this, that even we can also say here that even the finance minister, on the initiatives of Honorable Prime Minister, has issued various relief measures to the tune of 20,000 crore rupees, 20 lakh. I think, I don't remember the exact figure because it's very difficult to remember such a huge figure. 20 lakh crore rupees were given. Various news items came into news where central government as well as the state governments, both I'm talking about Delhi government as well as the union government and various state governments, they very elaborately said and requested that they made an appeal to their people. Government made an appeal that I would say advisory was issued by the government that in cases of all the landlord should don't put pressure on the tenants. That kind of advisory was given. All these advisories, etc., were not having any basis. They were just advisories. They said, okay, do charity, something of that sort. They were not backed by any financial things. If the tenant is not able to pay the rent, the government will be paying it. It's what we call it in Hindi, Jubani Jama Kharch. आप मायना इसका पूछिएगा क्या होता है जुबानी जमा खर्च का. But even the banks, they postpone the EMIs for 3 months, and you will be surprised if you are postponing your EMIs for 3 months, you will have to pay the interest for that 3 months. What a big thing is done. And so much of human cry for this, that the banks have postponed as a matter of fact, nothing big was done, I must say. Now, I would also like to mention here that before our own Honorable Delhi High Court, before Justice Pratibha Singh, a case pertaining to this particular subject which we are discussing today came. Now, what exactly was the outcome, if I tell you? The Delhi High Court divided. It says in its order, the learned judge has said that there are four kind of tenant landlord disputes, where in such situation, one, where there is a force majeure clause is there, and in the force majeure clause it is specifically mentioned that in extraordinary circumstances like pandemic or some epidemic, what you are going to do. It is specifically mentioned, which to my mind, it is silent. Nowhere you will find such, because it is beyond imagination. You can't foresee such situation. Today you can foresee, but in December 2000 December 2019, you could not have ever foreseen that such situation will be there, or years prior to that. You can never foresee such situation. That is one. Second situation is where force majeure clause is there in as a standard term. Third situation, landlord tenant, I'm talking about. Landlord tenant, the third situation is where there is no agreement between the parties. And fourth situation, as per the Honorable High Court, is where there is a profit sharing agreement. What will happen in these four situations? Except the first situation, where it is specifically mentioned, where it is specifically mentioned in the agreement that if there will be any pandemic and in situation the office is closed, situation will remain out of control of both of us, we will not pay the rent. If it is specifically mentioned, then only the rent will be, they will be allowed to not pay. So explicit language, in explicit terms and conditions, it should have mentioned there. If it is explicitly mentioned, then only you can stop paying. So broader principle of contract will be applicable. If there is an agreement, that agreement will supersede all these conditions. The force majeure clause will not come to rescue the tenant as far as pandemic situations are concerned. This is what is the current status. This is what is the situation. Now, I put a question to myself. Now, what is the solution? The solution to this is, what is the solution? Nobody gave us the solution. We discussed force majeure clause. We discussed doctrine of frustration. We discussed, which is defined in section 56 of the Contract Act. We discussed section 108(b)(e) of the Transfer of Petition Act, Transfer of Property Act, TPA as we call it. We discussed Epidemic Diseases Act 1897. We discussed CRPC. We discussed all the National Disaster Management Act. Everywhere we can just discuss, but solution is not in front of us. Various government advisories, various governments notifications that right to the tenant should be protected. Delhi Rent Control Act we discussed. The State Rent Control Acts we mentioned here. We mentioned all situations where tenants are equally sufferers, if I may say so. But what is the fault of the landlord? He is also a sufferer in that case. Now, what is the solution to it? The solution is, as our Prime Minister says, become Atmanirbhar. The solution is that both these parties Landlord and tenants should sit down. Mediation is the solution, I feel. The solution is sit down. This is the problem. I am suffering from this. You are suffering from this. I can understand the store, the office was closed for 3 months. I can understand that. Similarly, you have to also appreciate this is my property. I'm paying all kind of things. I have invested huge money. I should get some return. I have family to, run, and I have to pay the bank loan payment, etc., etc. Whatever is the situation. So both the parties have to sit down, negotiate, and come to an amicable solution where both the parties should decide where and what they should do as far as this particular situation, the period, the rent payment is concerned. So I feel, Bhumika, that's precisely what my mind says about the current topic which you have assigned to me to speak on. Now I would request all of you, if anybody has to ask anything I could, if I am able to answer that, that'll be great. Please.
The audience can put in their questions in the chat box. Meanwhile, we have a few questions here, sir. It says, I'll prompt it to you. The first question is, will force majeure be applicable even when time is of essence in contract?
Of course. That is very true. If even time is the essence or not essence, if the force majeure situation, and there are two conditions of force majeure, when the force majeure will be applicable, there are two conditions. If those two conditions are fulfilled, yes, whether time is the essence of the contract or not, that will not make any difference.
So also there are further audience wants to know the relevant judgments which were quoted by you, which were relevant to this very whole point of tenants and their liabilities.
Well, as far as the current pandemic situation judgments,
yes, sir. Yes, sir.
I think I have quoted, as far as the 2020, I have quoted 3 judgments here, rather 4 judgments, if I may say so. I would be feeling sorry I couldn't give you because it is not there in my mind. I cannot provide you the citations, but I can certainly guide you from where you can get it. For 2 judgments I have quoted from the 2 high courts. One was Karnataka High Court, and another was Delhi High Court. Just put it in the Google. You will get, it was quite well in the news. So you can very well. And similarly, 2 judgments I have quoted for Supreme Court. Both of them are also available in the Google, and very recent ones. These are, and more so on all these 4 judgments, my interviews on various television channels are there, which are there in my YouTube. You can go and just put my name. You will see those videos are there. All the 4 videos I have discussed in various television programs. So there are 4 videos specifically for these 4 judgments.
Sir, we have one more question with us. It says that can the government orders be considered as impossibility of performance?
You have to really elaborate this question for me.
So, for example, if there's a order by the government which does not permit you to have a contract, or which does not let you follow the procedures or the agreements of a contract, so would that be considered as a part of impossibility to perform that contract?
Still I am a little confused about the question.
I tried to elaborate it.
I could understand what you are saying is, let me just give an example, because I would like to have, who has asked this question?
Sir, from the audience, can they brief up the question till that time? No worries, sir. You can continue with your viewpoint on this.
I think the question which was asked is this, that if any government order says that don't pay the rent, let's say, if this is the order, then what will happen? Or tenants are asked not to pay the rent. This is an order. Then first of all, if a government order is there, it is binding on each one of us. But there is no such order as far as my information is concerned, as far as I know. There is no order by the government, any of the government. Advisories were issued that, okay, please take care of the tenant, please, feed the poor. This kind of advisory. So advisories can be treated as advisory. If you don't, follow them, there is no penalty. There is no, though. So that is there. Advisories are there. But if somebody is there who doesn't follow the advisory, then I feel there is no offense. On the other hand, if there is an order, if there is a notification, and which is not being followed by the people, then it is not only condemnable but also punishable under the provisions of law.
So we'll take one last question over here, which is, for instance, if the owner and his sole income of earning is rent, so what can he do in this present situation if he is not
I
able?
couldn't get you. What you're saying? Please tell me once again.
Suppose to an owner whose sole earning is rent income, so if he's not able to get it at the same time during the COVID pandemic, so what is the solution or the balance between rights of a tenant and rights of a landlord? So no one is at loss.
Yeah, the only solution, as I said, is negotiations. You sit down, both of you, both the parties should sit down, and they can ask, let's have a midway kind of thing can be there. Now, I was reading another question some girl from Bhubaneswar was asking about as to what is the law for PG students, whether they should pay. Now, again, my answer is same. You must negotiate with the person. You say that, look, no electricity, no water, no food, nothing we have taken. Only we have asked you to keep our, place intact. I have seen, they are charging less than in that case.
So I think that sums up the whole session very nicely. You have answered.
No, I feel there are so many other questions are coming. What will be the solution if the landlord is not ready to consider matter amicably and continue? Then there is no solution to it. That is what I feel. There is no solution. The law is in favor of landlord. Very, very frank and blunt on it. So law is in favor of tenant. Now you have to show your skills. You have to use your strength. Whether I'm not talking about the muscular strength. I'm talking about all kind of whatever pressures you can put. Then you should put that. Mere hardships to perform the contract does not mean impossibility. Exactly, very correct. Who has written this? I don't know. Jaiswal, is that Tanmay? Can tenant ask landlord to lower rent due to? Yes, that is what I'm saying. This is what is required. Commercial lease is new big problem in India. What are the provisions for it? Commercial lease is new big. I mean, that's the same thing. Commercial lease is not something new. It is absolutely the same thing. Lease agreement, whether it is commercial, residential, it covers both aspects. So that's what I feel. There's so many of my students are there. Aditi, now you've woken up. What if tenants already gave notice to the landlord leaving the flat before lockdown? Yes, then they can go, leave it without paying. Then if the tenants have given the notice and locked on, that is, you can certainly fight for it. We were not staying here. It was not used and we are going. So certainly you can take little advantage of that. But of course, the end would be what is the amicable this thing. Students have given examination fee for the semester exam. But now government decides. Look, as far as the student fees is concerned, that is something certainly government is coming up with a notification on that also. And we have seen that many a time schools have to return the money. You must have seen it. Delhi High Court has passed so many judgments. Subhash Agrawal is the one who files his petitions in Delhi High Court. As the SC kept itself away from the interfering of situation, saying that policy matter, मैं पढ़ नहीं पाया. भूमिका पढ़ो आप.
Sir, it would be sent to me via WhatsApp. Just a moment.
Oh, no. Then I'll read it. Kunal Sharma. You know, all of you are here today, yeah? Kunal is also here. As SC kept itself away from interfering in the situation by policy matter by relying on the statement of issued by the government, but we have seen no policy has worked out in practical. Then isn't it a failure of judicial review power of the look? This is what is very important. Yes, that is the reason how after Supreme Court has passed an order, Karnataka High Court under its own powers of judicial review, as we call judicial activism, the Karnataka government, the Karnataka High Court said yes, there is a situation which is grim. We have to come in. That's what we are expecting, and that is how the judgment by the Supreme Court, which says that both labor as well as the industrialists have to come into an amicable solution. No, similar guidance, similar thing we apply here in cases of landlord and tenant. Why second point not fulfilled? Since there are layoffs, won't affect the ability of the parties. No, second point is Ikra, fulfilled, not fulfilled here. What are the two points? The first point is that the matter is beyond the control, and second point is that it gives an inability to perform. So here inability is not there. Where is the inability? He has to just pay. So inability means it is impossible. Of course, if you don't have money, then that is a separate scenario altogether. You leave the premises and that kind of thing. The answer, each and every case is different and separate in its own realm. Both the parties, look, as Delhi High Court judgment says that the case, there are 4 types of tenants. There are in malls, the owners of the mall has given the premises on rent on the profit sharing also. So what will happen? There he will get zero, nothing. Shop is not open, no profit is there, so nothing. So the fundamental point will remain here that that it is only that we all have to become Atmanirbhar now. Yes, anybody else has this? There are few questions are coming. In case the tenant landlord as central law, state law, in case of tenant and landlord, central or state, which more preferable?
Which law is more preferable, sir? Would the state law prevail or the central law prevail?
Look, as I said, this is a subject, tenancy is a subject which is where state law will have to be seen first, and that has to be applied.
So I think the questions would keep on coming up, and since we are short of time over here, maybe we can...
This Arushi has asked one. Can you read this question?
Sure,
the
sir.
Situation, many labor class moved to their village, but after some time they came back, but the landlord don't allow them to enter. And
and then the And then they sued the owner. So what's the opinion on that situation?
Look, I don't think anybody has sued any of the owners so far. I've not come across, because these landlords, these tenants are very small people, and it's a sad state of affair that people who are small in this country are taken on ride. We have seen, what to say about organized labor. Even, what to say about which is the labor which is not organized, unorganized sector. Even the organized sector is being pushed so badly. So, of course, the point from where I started is very, very relevant. You all have to appreciate that this is an extraordinary situation. We all are affected. Anybody whatsoever, we all are affected. And we have to have a mid path. We have to have a path through which the best of the best thing could come out. That's all I feel, and that is where I would. Anushka Kansal wants to say something. What is the private educational institution ready to negotiate? As far as the educational institutions are concerned, I feel that the government is going to come up with certain regulations the moment this need is there. And we have seen even courts interfering in such situations. So thank you very much to all of you for coming, and that's all I have to say.
Thank you,
You
sir.
have to ask anything. I'm
Sir,
very
all
happy.
the questions were answered very amicably, and all the points were covered, whether it be government policy or the solutions.
So the word used by Bhumika is amicably. So that is the key word today. We will leave on this note that amicably only you can resolve this situation.
Yes, sir, totally. It was very informative. I think everyone's doubts were cleared for the same. It was very insightful and informative, sir. And thank you for taking out the time and spending it over here and answering all the questions. Thank you so much, sir.
Thank you, sir, for joining us.
Thank you very much to all my students, all of you I can see, and thank you for coming. And this is a very nice platform, and they've been regularly in touch with me. All the dynamic people, be it Bhumika, Manish, Devyansh, Kanika, all these people are associated, and I wish all of you very best of luck. And all the students, you stay with me always in my heart. My great love, respect to all of you, and I wish many of you, I want to appear before you as when you will become judges. Premada is giving a smile. We have, all of you are very, very dynamic. Please keep working hard, and certainly you have lot of you guys have huge potential. I must say, the way you all have come here, 300 people are here. I must congratulate this platform that, and on the other hand, on YouTube and all, there's huge pressure has been just messaged to me by Devyansh. So very nice, good. Keep doing the hard work. There's no, dearth of, good things which will be there in front of you.